Environmental law is failing. What do I mean? Environmental law regulates the relationship between humans and nature. It seeks to protect and preserve the environment, but indicators point to persistent ecological degradation resulting from human activities. Looking at the development of international environmental law, it is possible to distinguish three eras. The traditional era focused on natural resource management. Emphasis was placed on state sovereignty so long as transboundary harm was avoided. The modern era can be seen as a response to the growing ecological consciousness of the 20th century. It saw greater cooperation between states, resulting in a huge growth of multilateral environmental agreements to address specific issues. The postmodern era saw a shift towards pluralism, with the rise of sustainable development as a dominant paradigm. When analysing the failure of environmental law, it is important to consider the question, why do we, as humans, protect the environment? I submit that the development of international environmental law must be viewed as overwhelmingly anthropocentric, meaning that human beings are regarded as central and reinforcing an artificial separation from nature. It is inherent in the word environment, that what surrounds us. Viewing the environment as a mere object permits ongoing ecological devastation. A fundamental reinterpretation of environmental law that rejects sustainable development as the dominant paradigm is required. Ecological law recognises the wider community of beings beyond humanity. Practical examples can already be seen at the domestic level. The Ecuadorian constitution recognises independent rights of nature. Individuals or groups are permitted to call upon public authorities to enforce these rights. Legal personhood has been granted to the Whanganui River in New Zealand. This seeks to recognise, in some sense, traditional indigenous construction of nature. An official guardian represents the human face of the river. Also, a regional Indian court has recognised rights for the Ganga and Yamuna rivers. At the international level, various initiatives, such as the Earth Charter and the Universal Declaration of the Rights of Mother Earth, have sought to recognise nature as a subject of law. My research specifically addresses the role that international courts and tribunals can play in the development of new norms. Judicial intervention is often required in response to failures of existing governance structures. The International Court of Justice has played a significant role in the mainstream of sustainable development during the postmodern era. It is time to move towards a new paradigm of international ecological law that recognises existing developments at the domestic level.